This morning, we will be talking about copyright protection for design features beyond cheerleaders and shovels. And my colleague, Jeff Cadwell, is really going to be leading us through that this morning and describing recent developments in this area and the state of the law here and how that impacts everyone's business going forward. So good morning, Jeff, and do you want to start us off with some comments about how it is that we picked this topic?
Good morning, everyone. Thanks, Jennifer. So we obviously have the Supreme Court who issued a decision in March in the Star Athletica case, which involved cheerleading uniforms and the designs on the cheerleading uniforms. And that case was important because it set forth a uniform test, no pun intended, for determining whether the design of a useful article can be protected. And this resolved the inconsistency of at least 10 different approaches across the various circuits and academics involving the idea of separability, which we'll get into in a bit. And so this decision is obviously very important for companies that make useful articles, for example, chairs or shovels, which we'll also talk about, and those articles that happen to have aesthetic features. How can those be protected? And so I think to kind of give you the roadmap for today, what we'll do is we'll go through kind of the background on this whole separability issue, and then we'll talk a little bit about the Star Athletica case itself, and then a few subsequent developments that have happened since March that are of interest. And I think one thing to remember here when we talk about separability is that this is not the end of the inquiry. There must also be copyrightability. And the Supreme Court noted that in the Star Athletica case that it was actually making no determination as to the copyrightability of the designs. It was just setting forth a test for separability. So let's move into what the tension is here. And that is that we have companies who are designing all sorts of articles that are necessary for our everyday lives: chairs, silverware, shovels, and companies want to find a way to set themselves apart from their competitors. And obviously there's other ways to do that, like trademark or potentially patent protection, but in some ways, useful articles, it's easy to put on aesthetic features that may be an identification that is relevant to the company, and companies want to be able to recoup the value that they invest in coming up with these designs that they put on useful articles. And I think the tension in the law is how do you protect those aesthetic features without inadvertently granting a monopoly on the utilitarian article itself? To borrow from the Star Athletica case that we're going to talk about, how do we ensure we're not actually just providing copyright protection for shovels as shovels, right? And so when we look at this whole idea of separability, which is what this is about, the courts have struggled with how do you separate those design features, those aesthetic choices that are made in creating a useful article from the useful article itself to determine whether those design features should merit protection under copyright law. And one thing we'll want to talk about in terms of practicality here is, one way of protecting that investment in the design features is copyright registration, and the idea that courts typically give deference when the Copyright Office grants a copyright registration. And so one of the takeaways that we'll come to is that when you are coming up with useful articles that have aesthetic design features, securing copyright protection is a very good idea for a number of reasons. And then before we kind of get into the meat here, talk a little bit about the different types of protection. Obviously, what copyright is meant to protect is works of creative expression that are fixed in a tangible medium of authorship. And so typically in the separability cases, we're talking about sculptural works or other types of three-dimensional items. Copyright protection lasts an awful long time. If it's an individual who's created it, you get the life of the author plus 70 years. If it's a corporate created work, like a work made for hire, the protection lasts 95 years from publication or 120 years from creation, whichever turns out to be shorter. And the work is protected under law immediately upon fixation, but registration has certain benefits. And contrast that with design patent, and since Jennifer's a patent specialist, I kind of ask her to talk about how the patent protection would work.
Yeah, sure. And on the patent side, certainly there's also this struggle as between protection of the utilitarian function, which is the realm of utility patents, and the protection of aesthetic design features. And so the design patent was intended to be able to protect that also, these aesthetic features of a particular product, basically the look. There's a much shorter term, 14, 15 years, with that 1 to 2 year process being factored in to get the patent issued. While the design patent process is certainly less expensive to go through than a utility patent process, for those of you who have been through the utility patent process, that can take 3 to 5 years. The design patent process from filing to grant can be significantly shorter, but simpler than the utility practice. It'll be interesting to contrast with the registrability bar in copyright that design patents are examined for novelty and non-obviousness over other designs. So you have to meet a hurdle of sort of a non-obvious design relative to other designs that are around or have been around at the time. So certainly there are some differences there significantly in terms of term and then how those rights are perfected.
Great.
Let's talk to Jeff about once you have these, because I think another thing that's interesting that clients sometimes struggle with, particularly in this area, where between trademarks and copyrights and design patents, there's many ways to protect these aesthetic features. So let's also touch on what remedies are available. So if you go to enforce your copyright, let's talk about that a little bit and how, what you're able to recoup under the copyright, and then we can talk about the design patent remedies also.
Sure. And to enforce at all in the United States, if you are a United States-based company or author, you actually need a copyright registration. I mentioned that copyright comes into being upon fixation, but a registration is actually the key to the courthouse door under our federal law. And so you would need to register to be able to sue another party for infringement. And the Copyright Act has statutory damages available, which is a nice feature. But to take advantage of statutory damages, you have to register your work within either 3 months of publication, which in the case of a useful article is typically going to be the first sale to the public, or prior to when the infringement occurs. And if you meet that threshold, then you can claim statutory damages of anywhere between $750 to $30,000 per act of infringement, and it's an as the court considers just type of an award, and the court can actually increase the award to $150,000 if the infringement is found to be willful. That is a nice feature because then you don't have to go to the task of proving actual damages and figuring out what the defendant's profits are. But if you don't meet the threshold of the 3 months of publication or prior to infringement standard, you can still request actual damages and the defendant's profits. And that's an election if you do meet the threshold. So if you think there's a lot more money at stake than the $150,000 for willful infringement, you might elect actual damages in lieu of statutory damages. And then the other remedies that are available under the Copyright Act are, of course, an injunction, and then potentially, depending on the severity, impounding and destruction of the infringing articles. And so just another quick note about registration before we talk about the design patent remedies is that if you're registered within 5 years of publication, it's going to be presumed valid by the courts. And as I mentioned, the courts often will give deference to the Copyright Office. So if the Copyright Office has granted a registration, then there will be some presumption that the work was copyrightable. And then you can record your copyright registrations with Customs and Border Protection, so you could potentially have counterfeit goods blocked at the borders and destroyed. So Jennifer, how does that compare to the design patent remedies that would be available?
So if you go to enforce your design patent, you do need to show, there's not a statutory number award for damages, but there's certainly provision for no less than a reasonable royalty, so you'd be looking into what a reasonable royalty for the design is. Or design patent holders can choose to receive disgorgement of profits basically from the infringer, which has gotten, that particular provision of design patents has gotten a lot of attention recently, as it was responsible for the original very large award in the Apple-Samsung rounded corner phone disputes, where they were awarded the disgorgement of profits on basically the entire phone, so there's some discussion now in design patent law about how to properly apportion the portion of profits that are attributable to that design feature, rather than disgorgement of all profits on the article. So that's an evolving area of design patent law, but that can be the ability to retrieve the profits can be advantageous under design patent law as well.
And so you may be thinking, is there a reason to pursue copyright instead of design patent, or design patent instead of copyright, or can you do both? And I think the answer is clear that these are not mutually exclusive means of protection. The courts have consistently said that copyright protection and design patent protection can coexist. And so I think as companies are thinking about these sort of utilitarian articles and means of protection, it's wise to talk to counsel about what's the best mode of protection for this particular article, or should we be pursuing both?
Yeah, right. Multiple gives you those choices when it comes time to evaluate what actions to take against infringers.
So I think with that kind of backdrop, let's move into how we got to Star Athletica and some of the background. And this idea of separability really took off in a 1954 Supreme Court decision, Mazer versus Stein, which involved lamps that had, the lamp base was shaped like ballet dancers. And there's kind of an interesting background in this area of law. A lot of treatises call these Balinese dancers, which is actually incorrect. They are ballet dancers. And I noticed around the time of the Star Athletica decision, one of the counsels from the Copyright Office actually posted a picture of the deposit copy for these statues to confirm that they were ballet dancers and not Balinese dancers. So there's a random tidbit for you. But basically, the plaintiff here said that the defendant had basically ripped off the statue design, and the defense was, well, this is a lamp base, it can't be protected because it's a useful article. And the Supreme Court held that the design of the lamp base could be protected under copyright law, independent of the fact that it is a lamp base. And the court was careful to note that this doesn't mean that they can stop anyone from using any sort of figure on a lamp base. They can only prevent copies of the particular lamp base. So the protection is in the actual sculptural element there. And based on that case, the Code of Federal Regulations was adopted in 1960 to say what we have here, that if a shape of a utilitarian article incorporates some sort of aesthetic feature, that protection or registration is eligible if that feature can be identified separately and to be existing independently of the work itself. And so that's where we get the idea of separability. And then in the 1976 Copyright Act, this concept was imported and codified into statute. And the relevant article here is Section 101 of the Copyright Act, which defines useful article. And then as you'll see in the bottom section, that the design of a useful article shall be considered a pictorial, graphic, or sculptural work only if the design incorporates features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. And so this whole area has tied the courts into knots because there was really no guidance here in the statute as to how to determine separability. The House report relating to the adoption of the 1976 Copyright Act did refer to the idea of physical or conceptual separability. And so we had some courts that went up and said, well, you have to be able to take those design features physically away from the utilitarian article to protect it. And you've got other courts that said, well, you can just imagine. If you can imagine it's a separate element, conceptual separability, then that's good enough. And in the Sixth Circuit decision for the Star Athletica case, the dissent noted that the law in this area is a mess, and it has been for a long time. And so let's take a look at what the mess was. There were, as I mentioned, about 10 different approaches to separability that the courts were taking. And I've identified a few here in the slides. And we'll kind of play the game, Jennifer, of what do you think? Do you think that the court in these various cases found the work to be protectable under copyright or not? And so one of the approaches was the primary subsidiary approach. And the test was basically that the feature is separable if the artistic features are primary to the subsidiary utilitarian function. And this case involved some belt buckles that had a particular decorative design, as you can see in those photos there. And so what do you think here, Jennifer? Do you think both separable and copyright protectable or not?
I'm going to go with no, because it looks like a belt buckle to me.
Well, so the court actually said that the primary ornamental aspect was conceptually separable from the utilitarian function of the belt buckle. And they said that these were not mere variations of a Western belt buckle, but instead rise to the level of creative art. And so in this case, the court found both separability and copyrightability.
I'm going to lose our game.
Well, let's take a look at the next one, which is called the design process approach. And here, the test was that the feature can be conceptually separable if the design elements are identified as reflecting the designer's artistic judgment independent of functional influences. And so this case involved, here we have a picture of a bike rack. And what do you think here?
Somewhere, I remember this case in law. I remember discussing this in law school, and so my law school professor somewhere is rolling around, but I don't remember the outcome of this case. I'm going to go with no. It's just a bike rack. See, I'm pessimistic about these things.
You got that one right. The court said it's not copyrightable because it seems clear that the form of the rack is influenced by utilitarian concerns, and thus any aesthetic elements cannot be said to be conceptually separable from the utilitarian articles. So apparently you design a rack that has a place for the wheels. No matter how you design it, under this test, the utilitarian function outweighs the design choices, and so no copyright protection under this test.
So they sort of considered that, here, that, like you say, the only reason that they're shaped this way, right, is to make room for the wheel. And generally any rack would have to have those dips, right, to accommodate wheels. And so having nothing here except those dips didn't rise to the level.
Right, but query if there were some sculptures on top of each of the little
right.
things on the top or something like that. Would those have been protectable? Probably so, but we don't know because of the simplicity of this design.
Right.
Then we had the likelihood of marketability approach. And despite valiant efforts by our research librarians, we could not actually find photographs of what was at issue here, which happened to be casino uniforms. And basically the test here was that the feature is conceptually separable. Even if the article had no utilitarian use, it would still be marketable to some significant segment because of the aesthetic qualities. So just picture a casino uniform. What do you think? Copyrightable or not copyrightable?
I'm going to go with no, because no one's going to buy it without it being a uniform.
Yeah, and I think this one may have been a fact-specific case, but basically the court said that the plaintiff had made no showing that its designs were marketable independently of the fact that they were casino uniforms. And they noted that the plaintiff had said there are costume museums that have extravagant designs featured in them that might also have utilitarian qualities, but that the plaintiff hadn't demonstrated that actually its uniforms would have been eligible for such a museum because of their aesthetic features. So the fact that these were just casino uniforms was not good for the plaintiff here. And then kind of finally to summarize a couple of the other tests that got us into the mess, we had the objectively necessary approach, which said that the feature is separable if the artistic features of the design are not necessary to the performance of the utilitarian function of the article. And then we had the ordinary observer test, which basically said that there's separability if the design creates in the mind of an ordinary observer two different concepts that are not inevitably entertained simultaneously. So untangle that one. And then we had the standalone approach, which says that a feature is conceptually separable if the useful article's functionality remains intact once the copyrightable material is separated. So in other words, if you can take away the design and the thing is still functional, then potentially there's some separability. And then there were a couple of academic articles that set forth some tests that the courts have talked about. One, the Patry approach that said if the work is the design of a three-dimensional article and the design is not a useful article, then there's no need to engage in a separability analysis. And then there's a Larby article by Barton Keyes that's often cited that suggested a two-part balancing test, which balanced the degree to which the designer's subjective process is motivated by aesthetic concerns and the degree to which the design of a useful article is objectively dictated by its utilitarian function. And so based on all of this, you can see why the dissenting judge in the Sixth Circuit in the Star Athletica case threw up his hands and said, this is a mess. The Supreme Court or Congress or somebody needs to resolve this so that there's some certainty into how designs are going to be evaluated under copyright law.
Because could plaintiffs at this point, prior to Star Athletica, then, forum shop to a certain extent for the tests that they liked?
Yeah, you would have been wise to do that to the extent that that was possible based on the facts of your case, because you would want to determine what the separability test was in that circuit and then whether you would be on the right side of that or not. So let's go to Star Athletica, which gave us, again, no pun intended, a uniform test for separability. And we've got here some of the designs that were at issue in the case. And so at the bottom is Star Athletica, which is the alleged infringer here, and then Varsity Brands at the top, which is the petitioner. And so you can see the designs that Varsity had registered with the Copyright Office, and then you can see the uniforms that Star Athletica made that gave rise to the complaint. And initially, the district court ruled against Varsity Brands on the ground that the cheerleading uniform was inseparable from its colored designs, and therefore the designs were not entitled to copyright protection. And then the Sixth Circuit reversed on appeal, concluding that the designs were separable from the functionality of the uniforms themselves. And so we had an appeal to the Supreme Court. The Supreme Court took the case, and we were given the test. And so in a 6-2 opinion with the majority opinion authored by Justice Thomas, the test was given that an artistic feature of a design of a useful article is eligible for copyright protection if there's two things. It can be perceived as a 2- or 3-dimensional work of art separated from the useful article, and if that work of art would then qualify as protectable pictorial, graphic, or sculptural work on its own or in some other medium if imagined separately from the useful article. And it's important to note that the majority opinion dispenses with the whole idea of the physical separability test. So the majority says conceptual separability is the way to evaluate. And the court goes to great lengths to talk about how the test that it sets forth is consistent with precedent, going back to the Mazer versus Stein lamp-based case that we talked about, and also with the statutory language in the Copyright Act. So that's our test.
And it does, though, Jeff, retain this notion of separate, right? I mean, there's still some mental work that has to be done to consider those things, to pull them apart, I guess, here in your perception or in imagination, I guess, are the words that are more used in this test. So there is still needs to be some effort to articulate the two different aspects and be able to articulate those separately. Is that right?
Exactly, and that's borne out in Section 101 that, you know, those features have to exist independently of the fact that it's a utilitarian article. So there has to be separability, and Justice Thomas, for the majority, said it has to be conceptual separability. So all you have to do is perceive that it could be separated from the useful article itself. And then, if so, would it qualify as a copyrightable work?
Yeah.
And I think it's important to note Justice Ginsburg's concurrence with the opinion, where she basically said that the works at issue here were not actually useful articles, but that the registration was for 2D artwork and fabric design artwork, not for cheerleading uniforms. And so what Varsity had done was just reproduce the works of art that it had registered on cheerleading uniforms. So the discussion about separability was not really necessary, she did not think, but she concurred with the opinion as written. And then we had...
Because the actual registration really was just for the artwork, is that...
Yeah, there's potentially the deposit copy. I haven't dug around for all of the various deposit copies, but on the very left at the top there is potentially one of the things that was submitted as a deposit copy. And, I suppose you could argue that it was a rendering of a cheerleading uniform and not a 2D artwork, but be that as it may, Justice Ginsburg was looking at the actual copyright certificate where the claim of authorship, which is what you have to identify you're trying to register, was 2D artwork and fabric design artwork. So they had not identified they were trying to register uniforms, which the Copyright Office probably, if you did that, would push back and say, well, aren't you trying to register the design and not the uniform itself, because we're not going to let you register the uniform. So then we had the dissent, which was Justices Breyer and Kennedy, which really, I think, kind of harkened to the standalone approach we talked about, and that basically they said that if the claim feature can be extracted without replicating the useful article and the result would be a copyrightable artistic work, then there's separable design. But if extracting the features would bring along the useful article, the design is not separable from the useful article. And so I think they got hung up a little bit on the fact that these were cheerleading uniforms. And so if you literally took the design off the uniform so that the uniform became just a white uniform, when you pasted that design onto a canvas or somewhere else, it would still look like a cheerleading uniform. And so I think that was troubling to them because they felt like that was granting protection to the design perhaps, and that there wasn't separability. And in rebuttal to that, and where in the world did we get our title, I think footnote 2 is really illustrative of how to think about these issues. Justice Thomas in the footnote talks about the dissent. Now, it's interesting, he says that the dissent would lead to the copywriting of shovels because the dissent actually doesn't mention shovels. But in any event, he uses shovels as an example. And to kind of summarize what this footnote says and what we can unpack a bit is, if you were to hang a shovel in a museum, go down to Lowe's and buy a shovel and hang it in a museum, it's still a shovel, right? But if the shovel has independently perceived artistic features, those features could be protected. So we look at our garden variety shovel right there. If there was some artwork on, say, the brown wooden piece on the handle, then potentially that artwork could be protectable because you could separate it from the fact that it's on a shovel handle, and you could put it on a canvas or anywhere else, and it would stand alone as a work of art. So if there's artistic features, those can be protected. Likewise, if you were to draw a shovel or to paint a shovel, that drawing or that painting of a shovel could be protected, right, as a work of authorship. But the shovel, as far as it's a shovel, cannot be protected. So if it's a plain shovel like we have there, there's probably no copyright protection.
It's interesting to think about, again, sort of with reference to our earlier discussion as between design patents and copyrights, and as I listen to this and see the quotations and things, and this notion of the graphic element or the design element for the purposes of copyright needing to be considered more like a work of art or having this artistic aspect to it, right? So like you mentioned, if you had sort of somehow decorated the handle or presumably the actual shovel base, that would be an easier question under copyright. I feel like in the design patent realm, you could get away with more in terms of the actual design of the shovel itself. It's an easier thing for the design patent realm to consider is how did you actually design that shovel, right? What's the shape of the shoveling element and the length and the shape of the handle, and then because they're examining it in the design patent realm for novelty and non-obviousness, they are more comfortable with those sorts of design elements that might contribute to the utility but are nonetheless choices, but maybe wouldn't be considered artistic, if that maybe makes sense.
Yeah, and I think that's where this gets really complicated, and we can kind of discuss what the implications are, because the artwork on the shovel handle, that's kind of an easy example. But what if instead of a painting on that brown piece of wood there on the handle, what if it were 5 different colors of wood, little rings of wood? Would those be protectable under copyright law? Could you perceive those 5 pieces of wood independently if they're different wooden tones, or maybe red, yellow, blue, green, violet, or something like that? That becomes a closer call. Perhaps a court might say, well, you could separate that out because we could perceive that there could be blocks of color like that would appear on a canvas. But then your hurdle might be, is that actually copyrightable? Because the Copyright Office is pretty clear that, standard designs and features, they even use the phrase zigzags and chevrons, I believe, in the examination manual, which is interesting in the varsity case. But they say that there has to be some sort of copyrightable work of authorship. So it's interesting to think about where's the line going to be drawn on these sorts of things? What if it's not those blocks of color, but what if the blocks are different sizes? Maybe there's a large block of brown, and then there's a small block of yellow, and then maybe there's a block with, a face on it, and then another block. What becomes separable there? So I think the real battleground is in the tough cases. The easy ones are probably if somebody paints a painting on that wooden part of the shovel. Well, I think we can all decide that that's separable. We could conceive of it being separated, and that it's probably protectable. But the harder point is, what about the more nuanced choices that companies are making?
Yeah.
And so, one thing we haven't talked about, just in terms of kind of leveraging protection, we've talked about patents and we've talked about copyrights, but kind of thinking more about the blocks of color or the arrangement of the shapes, is there, under trademark law, there's protection for anything that becomes a source identifying feature of a product or a source identifying mark. And so, product design trade dress is available if you can show that consumers associate that product design with your company. And so if you had those generic blocks of color, red, orange, green, blue, violet, or something on the shovel handle, and you couldn't meet the copyrightability threshold, if you could show that you use that on, say, all of the tools you produce, you make garden shears and shovels and everything else, and they all have those blocks of color, then potentially your mode of protection is not copyright law, but trademark law, to claim that that's a source identifying feature. And so that's yet another tool in the arsenal of an industrial designer in terms of thinking about how to protect the investment they're making in trying to set their products apart from others.
Yeah, so really, are you using that feature, that design element across your products as evidence of your brand and some brand recognition capacity, or is it really decorative of one particular object on its own?
Exactly, and so I think these are the choices that companies will or should already be grappling with. Is how are we trying to set ourselves apart from our competitors in terms of designing useful articles, and then what's the best means of protection? And if copyrightability is not available, then is there some way to get to the copyrightability threshold so that maybe you can claim copyright protection, design patent protection, and even over time source identifying trademark protection? And then you've got another tool in the arsenal. So
with that, Jeff, do you want to talk about sort of what happens now after Star Athletica?
Yes, we haven't really had any of the tough cases that we've just been hypothesizing about, but we've had at least one district court decision that talks about Star Athletica, and then we've also had a Copyright Office registration opinion that we can talk about. The district court decision came out of the Central District of Illinois at the end of June and involves, I believe these things are called Sparrow Clips, which are basically clothespins with the shape of a bird on top, and we've got them reproduced there on the slide, and they come in various colors. And this case was actually decided on summary judgment prior to the Star Athletica decision, but the parties requested reconsideration of the summary judgment order after Star Athletica, and the decision didn't change. The court actually before had found that there was protection, and then, as we can see here, and we'll talk about in a second, they applied the Star Athletica test and found that there's still protection for these Sparrow Clips. And so remember the test, which we can go back to here. There's protection if the design feature can be perceived as a 2- or 3-dimensional work of art separate from the useful article, and if that work of art would be protectable on its own if imagined separately. And so in the Central District of Illinois' opinion, they said under the first part of the test, the bird portion, the part above the clothespin, can be perceived as a separate 3-dimensional work of art. You could see a bird in what's there. And then secondly, that bird portion would qualify as a protectable sculptural work on its own if it were imagined separately from the useful article into which it was incorporated. And so you've got a very simple rendering of a bird in, I assume, wood or plastic, and the court is saying that's protectable under copyright law. And I think, there's some implications here for this sort of thing. This case involved direct kind of knockoffs, but I think the thing to think about with copyright law is that copyright infringement exists independently of what the goods are. It's not like a trademark concept where you say, the goods and services are related, therefore there's likely to be confusion. If you replicate a design that's protected in some other medium, you could still be liable for copyright infringement. And so what are the implications of finding a shape of a bird like that protectable? If I, draw that bird on a canvas and hang it in a museum, am I subject to a copyright infringement suit from the design holder? Potentially, because they've said that work there, that bird is protected under copyright law. And so I think that's another area of battleground that may come out of these is, if we start to see more simplistic designs protected, do we see more claims of copyright infringement based on that? How many ways are there to depict a bird if you were to draw an outline of a bird, right? And obviously, courts are sensitive to this and have been for years when they've decided copyright infringement cases, because they look at, what's the level of artistic merit of the work, how simple is it versus how ornate is it, and they look at substantial similarity. But, I think this case is interesting because it didn't involve a really complex design. It involved the outline of a bird.
And Jeff, does it relate to what was registered, how much is protected? Like, is the protection here for the bird on the clothespin, or really then the bird itself? Like, do you make a choice about that at the time of registration, or is that sorted out later, as it were?
You would, and I did not pull the registration for the Sparrow Clip, but I think that one thing you would probably do if you were to file for this is you would claim the bird portion and probably exclude protection of the clothespin, because that's a pretty standard design of a clothespin. I don't think that you would be able to claim that design of a clothespin is unique and that you have original authorship over that.
Yeah.
So my guess is that the copyright registration covers the bird element.
So it's really then that bird element then appearing anywhere in the clothespin sort of becomes irrelevant to the actual protection.
Right. The fact that it is a clothespin is in some ways irrelevant too. Right. Yeah. Just like the fact that the painting we might put on the shovel handle, the fact that it's on a shovel handle is somewhat irrelevant because the protection is for the artistic element and not the shovel. So, the Copyright Office, which we've talked about is an important place to be if you're in this area to try to get your designs registered, is, they're on top of these issues. They've, for a long time, had standards for how they evaluate separability and protectability, and they're actually in the process of releasing a new compendium of practices. And for those who don't know, the Copyright Office Compendium, which is available at the Copyright Office's website, is basically the examination manual. It's akin to the Trademark Manual of Examining Procedure and the patent manual that's used at the PTO. And so this is how examiners look at things that are submitted for registration. And the compendium involves citation of case law, Federal Register, all of the sources of law that inform copyright registration. And basically they punted at the moment in their newest edition, and they're saying they're developing updated guidance on registration of these features. So we'll get some more guidance hopefully soon on registrability, but obviously the office is going to be looking at things through the lens of Star Athletica. And we have one example of that already happening, and that's on our next slide here. It's almost lunchtime here in Minneapolis, so there's a piece of pizza, and getting a little hungry. But this is actually not a piece of pizza. This is a pool float that's shaped like a piece of pizza. And the applicant had applied to register the copyright in the design on this pool float. And the application was actually filed by the entity Big Mouth Inc. on August 18th, 2015. So it predates the Star Athletica case. The registration was refused by the examiner. the applicant filed a request for reconsideration, which is basically the means by which you appeal a refusal at the Copyright Office. The registration specialist again refused the claim, and then they filed a second request for reconsideration of the pool float, and the decision was just issued on July 11th, a few days ago in this one. And the Copyright Office talks about the Star Athletica case in its opinion, and so obviously the examiners are taking note of it. Here is interesting because the examiner agreed that it's possible to separate that piece of pizza from the pool float. So you could imagine that piece of pizza, to use our common example, splashed on a canvas hanging in a museum, right? But the problem was the Copyright Office did not think that there was requisite originality for this to be protected as a copyrightable work. The quote from the opinion is, while it's conceivable that some two-dimensional artwork of a pepperoni pizza slice could be copyrightable, in this case, the depiction is a very common version. Triangle slice, yellow cheese, brown crust, and circular red pepperonis. This garden variety representation of a pizza slice in the work does not raise the amount of creative expression to a level warranting copyright registration. So query, what do you have to do to register a pizza slice? You know, do you have to make the pepperoni green? That wouldn't be very appetizing, you know, if you had green pepperoni. Do you have to put more pepperoni on there? If you had pepperoni and peppers, would that be good enough? So I think the implication here is that what the office is potentially going to look more closely at the copyrightability aspect of a work, and the battleground again is going to be on whether it's protectable or not. And just, you know, based on personal experience, having filed a number of copyright applications, I've seen a lot more scrutiny over the last couple months from the Copyright Office, and I'm not sure why that is, but we're getting a lot more inquiries about what specifically we're trying to register or how we're claiming the authorship on applications. So I do think that the concept of protectability and whether the work is expressive enough to merit copyright registration is going to be scrutinized a lot more going forward, just based on what I'm seeing. And so I think that's going to be the battleground here. And so I think, you know, what are the takeaways from the Star Athletica case and just the discussion we've had today? I think obviously, you know, starting at the outset, when a company designs a useful article, whether it's a pool float or a shovel or something else, there should be consideration given to features that might qualify for some protection that would allow the company to set itself apart from competitors. And whether that's copyright protection, design patent protection, maybe trade dress protection, which is going to take longer to acquire. You know, what are the features that a company can put on its useful articles to give it the ability to claim some protection? If that protection could be copyrightable, if there's a decision made, then I think it behooves companies to try to register the copyright in those design features. And the primary reason for doing that is because, as we've seen and talked about, courts will often give deference to the fact that the Copyright Office granted a registration. And so if you can get over the fact that the Copyright Office said, yep, I think it's separable and protectable under copyright law, then you've got a registration that you can enforce and feel like the court will give some deference to. And I think as part of that, you want to be very cognizant of what your registration strategy is with the Copyright Office. For example, you know, Star Athletica potentially, you know, again, we didn't look at all of the deposit copies, but when you're talking about fabric designs, you potentially can register fabric designs with just a swatch of a fabric that shows a repeating pattern. And so, you know, if you're in the clothing industry, maybe not submitting photographs or drawings of clothing, but rather the fabric pattern that forms the clothing, because the Copyright Office for a long time has recognized fabric design as a protectable work of authorship. And so where that comes into play is considering closely what the deposit materials that you're going to submit to the Copyright Office are, And the deposit materials are basically the example of what it is you're trying to register that the examiner will look at. And so for a fabric pattern, you can submit a photograph or a swatch showing the repeating pattern. And that's maybe one way to get around the fact that you might submit something that looks like a clothing article, but just instead submitting the swatch of fabric. You can't quite get around that with sculptural works, like if you're trying to register a toy or a lamp base, you're going to have to submit photographs of the article itself. And so, then the examiner will see that it's a toy or a lamp base, and we'll have to go through the analysis. And then I think the final thing I would say is that registration of copyrights is actually not that costly in the big scheme of things. The filing fee currently is $55 to file a copyright application. You can do it online, and it's a pretty quick form to fill out. There are some traps for the unwary, and so it's good for me as legal counsel to say this anyway, but it's good to consult with your legal counsel about completing the form properly, because you do have to identify the type of authorship and who is the author, whether it's a work made for hire, whether there are assignment of rights. So there's some things that you have to think about very carefully. But filing registrations is not that expensive in the big scheme of things. And like we said, there's many advantages to having a copyright registration. And so I think it's well worth it to build the portfolio of works if you're in the business of creating and selling useful articles.
Great. Well, thanks, Jeff, for going through that with us. And I have certainly learned things about the way that the copyrights are handled that I wasn't totally aware of before, particularly on the registration side. So I think it's definitely interesting to see how this will all develop going forward and how companies choose to place those enforcement efforts and how they're protecting things. So thanks everyone again for joining us, and please do feel free to send us any questions or feedback, and do attend to the completion of your sign-in and CLE forms if you're interested in credit. Thank you.
Thank you everyone for listening.